A federal judge has unsealed a detailed inventory of items seized during the FBI search of Mar-a-Lago, former President Donald Trump's Florida home. The list includes thousands of documents, some marked top secret, along with dozens of empty folders marked classified. CBS's Robert Costa explains.
The detailed list of evidence taken from the former president's Florida estate revealed 48 folders marked as classified that were found empty. Some legal experts say that likely alarms investigators.
The government is under an obligation to find out where are those documents, who has seen those documents, where are they now?
In all, the list shows Trump possessed 103 documents marked as classified. 27 that were marked top secret, secret or confidential were found in his personal office at Mar-a-Lago. 76 more were seized from his storage room.
Hey everyone, welcome back. Adam is here. So what just happened, guys? A federal judge just unsealed over 70 pages of classified documents, investigation records, grand jury transcripts, sealed hearing proceedings, internal evidence memos, and they're devastating. The documents lay out in granular detail how Trump allegedly moved boxes of classified material to hide them, tampered with surveillance footage, and directed his own lawyers to mislead investigators.
And the House January 6th committee is preparing for its final hearing today. It's expected to expose new evidence, including new information on then-President Trump's state of mind. This as we get a new twist in the Mar-a-Lago documents investigation. The Washington Post reports a Trump employee claims to have received direct orders from Trump to move boxes of documents ahead of the FBI search. Chief Washington correspondent Jonathan Karl has the latest.
One of Donald Trump's own employees at Mar-a-Lago has been cooperating with the Justice Department, according to a new report in the Washington Post. The Post reports the employee told federal investigators that after Donald Trump received a subpoena for government documents back in May, the former president specifically requested the documents be moved. According to the Post, security camera footage from Mar-a-Lago obtained by the FBI corroborated the employee's description of events. The Post reports that the employee initially denied handling any sensitive documents. But during a second interview presented with the new evidence, the witness reportedly changed their story dramatically, describing moving the boxes at Trump's request.
It's all out now, unredacted, with no legal maneuver left to make it disappear. Trump's response? A full meltdown on Truth Social. Because he knows exactly what those documents mean. Let's get into the granular substance of what these unsealed transcripts actually reveal, because the reality contained within these pages is significantly worse than any speculation that preceded their release.
This is a CBS News special report. I'm Nora O'Donnell in Washington. We are coming on the air with some breaking news. The federal indictment against Donald Trump was just unsealed. We have it right here. And now, for the first time, we are learning the details of the charges that were brought against the former president, all related to his handling of classified documents after leaving office. And we've learned something new. There are actually 38 counts against the president, including the unlawful retention of defense information, which is an Espionage Act charge. There are also charges of obstruction and conspiracy. This is the first time in American history that a former president has been criminally indicted by the Department of Justice. The former president posted a video last night proclaiming his innocence, and there are some big changes to his legal team.
The government's theory of the case, now fully visible to the American public without redaction, is a prosecutorial masterpiece of narrative construction. It alleges, with extensive supporting documentation, that Donald Trump was in possession of 64 boxes of classified materials at his Mar-a-Lago estate and private club. And we are not discussing routine government paperwork or low-level confidential memos. We are discussing the crown jewels of the American intelligence apparatus.
The latest Justice Department's filings had us wondering here, a year after leaving office, just how many documents marked classified did former President Trump have at Mar-a-Lago? So we counted by the numbers. Our count starts in January when the National Archives received 184 classified documents, adding up to more than 700 pages of secret government information. Now in June, 38 more documents marked classified, filling 13 boxes. were turned over by Mr. Trump's legal team. Now, we've learned that at least 72 of these first documents were marked confidential, at least 108 secret, and at least 32 were top secret. Now, this 36-page filing from the Justice Department also reveals a written assurance from Mr. Trump's custodian of records that all classified materials had been turned over at that point. But then, earlier this month, over 100 more documents with confidential markings were seized in the FBI raid. So that's more than 321 documents in total.
Top secret documents, sensitive compartmented information that reveals sources and methods, nuclear secrets, military contingency plans, the kind of information that, if compromised, could result in the death of human assets and the catastrophic degradation of national security capabilities.
The unsealed federal indictment provides key details about the kinds of documents found at Mar-a-Lago. According to investigators, they included some of the highest levels of classification that protects the nation's secrets.
Former National Security Advisor John Bolton worked in the Trump White House.
This was a risk to national security beyond calculation.
Bolton told CBS News special handling suggests a special access program which can be so secret the government doesn't acknowledge its existence. The classified code TK, or talent keyhole, can refer to intelligence gathered from spy satellites. Formerly restricted data can refer to nuclear weapons capabilities. Florida Republican Senator Marco Rubio said there was no evidence the intelligence was compromised.
When the National Archives and Records Administration realized the scope of what was missing from the official record and began requesting the return of these materials, Trump engaged in a pattern of delay and obfuscation. When the Department of Justice escalated the matter to a formal grand jury subpoena, a legal instrument that carries the full compulsory weight of the federal government and is not subject to negotiation or refusal. That is precisely when the obstruction shifted into an entirely new gear. According to the detailed timeline established in these unsealed transcripts, Trump did not comply with the lawful subpoena. He actively defied it. Instead of instructing his staff to cooperate and return every single classified document in their possession, he allegedly directed his employees to move the boxes, to shuffle them like pieces on a chessboard across the sprawling geography of the Mar-a-Lago property, to secrete them in locations that would not be discovered by federal investigators executing a search. And the obstruction goes far deeper than merely relocating physical containers. The transcripts detail, in excruciating specificity, how the closed-circuit television surveillance system at Mar-a-Lago was allegedly compromised. The security footage, that impartial, unblinking electronic witness that would have documented precisely who was carrying specific boxes and the exact destinations to which they were transported, was either deleted, altered, or experienced suspicious outages during the critical window when the documents were being moved and concealed. This was not a technical glitch. This was not an unfortunate coincidence of timing. This was, according to the government's filings, a deliberate and calculated effort to obstruct a federal investigation, to destroy material evidence, and to render it impossible for prosecutors to reconstruct the full scope of what happened to some of the nation's most sensitive secrets. All of this is now memorialized in sworn grand jury testimony, in detailed witness statements, and in the government's comprehensive, minute-by-minute reconstruction of the conspiracy. And now the seal is broken. The public can read every word, and perhaps the single most explosive component buried within this unsealed trove is the saga of Trump's own attorney, Evan Corcoran. In the ordinary course of legal representation, communications between a president and his personal counsel are sacrosanct. They are shielded by the ancient and powerful protections of attorney-client privilege. But there exists a narrow, razor-edged exception to that rule known as the crime-fraud exception. This doctrine holds that if a client is utilizing the services of their lawyer not for legitimate legal advice but for the purpose of furthering a crime, to plan an obstruction, to draft a false statement, to conceal an ongoing conspiracy, then the privilege is eviscerated. It is as if the door to the confessional is forcibly breached, and Judge Beryl Howell, after conducting a thorough and secret review of the evidence presented by the special counsel's office, issued a ruling that Trump's communications with Corcoran fell squarely within this exception. She found sufficient evidence to conclude that Trump was using his lawyer as an instrument of his obstruction scheme. Consequently, the privilege was pierced. Corcoran was compelled to appear before the grand jury and provide sworn testimony against his own client. And the substance of what Corcoran revealed is now contained within these unsealed transcripts. He detailed, under oath, how Trump allegedly instructed him to mislead federal investigators, to falsely certify in writing that all classified documents had been identified and returned when in fact they had not, and to deliberately avoid searching certain areas of the Mar-a-Lago property where the concealed boxes were known to be stashed. Corcoran, demonstrating the prudence expected of an officer of the court, maintained contemporaneous notes throughout this period. He documented his concerns in real time. He created a paper trail, so when he was ultimately forced to take the witness stand, he was not relying solely on fallible human memory. He possessed documentary evidence substantiating the pressure he was under and the nature of the instructions he received. And then there are the photographs. The unsealed documents contain the now infamous images captured by the Federal Bureau of Investigation during the execution of the search warrant at Mar-a-Lago. These are not images of a secure, compliant storage facility. They are images of chaos and criminal negligence. Classified documents adorned with bold, unmistakable cover sheets reading, "Secret, No Foreign," an acronym signifying that no foreign nationals, regardless of their allied status, are permitted to even glimpse the contents, are depicted strewn across carpets, intermingled indiscriminately with random personal memorabilia, and stacked haphazardly in locations as inappropriate as a ballroom and a bathroom. The nation's most sensitive intelligence, the kind of information that could lead directly to the execution of human sources and unravel decades of painstaking intelligence collection, was sitting in cardboard boxes at a resort where foreign dignitaries and guests attend lavish social events, where waitstaff circulate to clear plates, and where housekeeping personnel change linens and clean surfaces. The photographs serve as visual, irrefutable proof of a complete and utter contempt for the Espionage Act and for the safety and security of the American people. They are images of a man who treated the country's most guarded secrets as if they were personal souvenirs. And now the public can see them. They are unsealed. They are part of the permanent historical and legal record. Trump's response to this avalanche of incriminating material is not a coherent legal defense. It is not a reasoned rebuttal to the specific factual allegations. It is a primal, guttural scream of panic. He is crashing out on Truth Social, branding the entire proceeding a politically motivated witch hunt, accusing the federal judiciary of weaponizing the courts against him, and launching broadside attacks against everyone involved in the process. The judge who unsealed the documents, the prosecutors who meticulously assembled the case, and the attorney who was legally compelled to testify truthfully. He is spiraling into a state of visible agitation because he possesses the situational awareness to recognize how catastrophic this evidentiary release is for his political and legal standing. He knows that these transcripts expose the mechanics of his obstruction, the audacity of his falsehoods, and the depth of his disregard for the rule of law. And there is absolutely no action he can take except to rage impotently into the digital void because the documents are out. They cannot be unread. They cannot be resealed. They belong to the public now. The timing of this judicial unsealing is particularly devastating for Trump. This is not occurring in a political vacuum. This is happening concurrently with a renewed and aggressive push for impeachment stemming from his apocalyptic threats regarding Iran. It is happening while federal judges across the country are issuing sanctions and restraining orders against his immigration enforcement policies. It is happening while his own senior military leadership is privately and, in some cases, publicly questioning his competence and stability. And now, these classified documents, case materials drop into the public domain like a detonation, reminding every American voter of the dense criminal cloud that has enveloped this man throughout his public life. Democrats are already capitalizing on this convergence of crises. They are pointing to the unsealed transcripts and the photographic evidence and articulating a clear, resonant message. This is the pattern. This is the fundamental nature of the man. He obstructs justice. He lies to federal investigators. He endangers the national security of the United States for the sake of his own ego and convenience. And he is doing it all over again, right now, in real time. Republican members of Congress find themselves trapped in a political posture that is functionally untenable. Mounting a credible defense of Trump's conduct regarding the classified documents is a task of near impossible difficulty. The evidence is not a matter of competing narratives or he said, she said ambiguity. It is physical. It is visual. The photographs are independently damning. The witness testimony from his own legal counsel is detailed, consistent, and bolstered by contemporaneous documentation. And now, the entirety of this evidentiary record is public. They can no longer hide behind the rhetorical shield of fake news or selective leaks, because this is the authentic, unvarnished record of the court itself. Defending a president who allegedly concealed boxes of nuclear secrets and orchestrated the tampering of security footage is a political position that defies coherent justification. So, let us pause and conduct a thorough dissection of the anatomy of this obstruction as revealed by the newly unsealed documents. This is not merely a source of embarrassment, it is a detailed roadmap to multiple felonies. The government's theory of the case begins with the 64 boxes. When Trump departed the White House, he took far more than personal effects and furniture. He took the operational intelligence of the United States government. When the National Archives recognized that critical documents were missing, documents that are the legal property of the American people, not the personal chattel of a departing president, they made initial polite requests for their return. Trump relinquished some boxes, but he retained the most sensitive materials. He kept the ones bearing the highest classification designations. When the Department of Justice escalated the matter to a grand jury subpoena, a legal demand that is not optional and carries the threat of contempt sanctions, the obstruction commenced in earnest. The transcripts detail a sudden and intense flurry of activity at Mar-a-Lago in the immediate aftermath of the subpoena's service. Boxes being relocated from the designated storage room to Trump's private residential quarters. Staff members shuttling materials across the property in a manner inconsistent with routine operations. And then, the gaps in the CCTV footage. The cameras did not simply malfunction due to technical error. According to the government's detailed filing, there were suspicious events and footage that was altered or deleted. This is textbook evidence tampering. It demonstrates a consciousness of guilt. Individuals with nothing to conceal do not delete security recordings that would exonerate them. And this brings us back to the pivotal role of the attorney, Evan Corcoran. He was caught in the cross-currents of this legal hurricane. Trump required him to sign a formal certification to the Department of Justice, attesting that a diligent search had been conducted and that all responsive documents had been returned. But Corcoran possessed the foresight to recognize that if he affixed his signature to a false statement, he would face the forfeiture of his law license and potential exposure to criminal liability. So he took notes. He documented the conversations during which Trump allegedly provided instructions that appeared designed to obscure the truth and avoid full compliance. When Judge Howell reviewed those contemporaneous notes in a closed, classified setting, she rendered a landmark legal determination. She concluded that Trump's communications with his attorney were not undertaken for the purpose of seeking legitimate legal counsel. They were conducted for the purpose of advancing a criminal enterprise. The privilege was destroyed. Corcoran's subsequent testimony now forms the structural backbone of the obstruction case. He allegedly informed the grand jury that Trump wanted him to lie by omission, to represent that the search was complete, and to deliberately avert his gaze from areas where contraband was likely hidden. And we must address the staggering recklessness of the storage conditions. The photographs from the FBI search constitute a national security horror story rendered in still images. We observe cover sheets bearing the most restrictive handling caveats in the entire government: top secret, SCI, and no foreign. These documents contain information pertaining to human intelligence assets and the capabilities of foreign partner services. They were discovered in a ballroom that had been utilized for large-scale social events. They were located in a bathroom accessible to resort staff. They were intermingled with newspaper clippings and articles of clothing. This is not a technical violation of an obscure records management regulation. This is gross negligence that approaches the threshold of intentional exposure. And Trump allegedly engaged in all of this conduct, according to the weight of the evidence, simply because he desired to retain possession of the materials. He wanted the trophies. He wanted the physical manifestation of power. And Trump's defense strategy? It lies in ruins. How does one effectively spin 64 boxes of missing classified material? How does one explain away the conspicuous gaps in the surveillance footage? How does one discredit the sworn testimony of one's own legal counsel? Testimony that is corroborated by handwritten notes taken in real time? The answer is that one cannot. The sole remaining instrument in the rhetorical arsenal is to attack the legitimacy of the institutions themselves. And that is precisely why he is crashing out on social media. He is screaming about weaponization and election interference because he lacks any substantive, fact-based rebuttal to the evidence contained within the unsealed record. The documents speak with their own autonomous, damning voice. They narrate a story of an individual who believes he is situated above the law, who believes the nation's secrets are his personal property, and who is willing to immolate anyone who attempts to enforce accountability. Let us connect this evidentiary record directly to the present political moment. Donald Trump is currently occupying the Oval Office, rendering decisions of profound consequence regarding Iran, regarding the deployment of American military forces, regarding the sharing of sensitive intelligence with allies. These unsealed documents prove, to a standard that is persuasive in the court of public opinion, if not yet in a criminal trial, that this is an individual who cannot be entrusted with classified information. He possesses a documented, verifiable history of removing the most sensitive national security secrets, storing them in an insecure and negligent manner, refusing to return them when legally obligated, lying about their existence and location, and actively obstructing the efforts of federal law enforcement to recover them. That pattern of behavior is not erased by the act of retaking the oath of office. It is a characterological defect. It is a behavioral inevitability. And it should provoke profound anxiety in every American citizen who cares about the integrity of national security. Let us now distill this complex and voluminous information into 3 key takeaways from this seismic unsealing. These are the points that will define the trajectory of the ensuing political and legal conflict. The documents provide irrefutable, documented proof of obstruction of justice. This is no longer a matter of subjective interpretation or partisan spin. The government has constructed a timeline that is devastating in its clarity and specificity. During the months of May and June, immediately following the issuance of the subpoena demanding the return of classified documents, there was a documented surge in the movement of boxes at Mar-a-Lago. Security footage captured aides transporting boxes to new, undisclosed locations. Subsequently, there were mysterious gaps and anomalies in the CCTV system's recordings, and then the lawyer's testimony under the compulsion of the crime-fraud exception. Judge Howell's ruling is itself a judicial finding that sufficient evidence exists to establish that Trump utilized his attorney as an instrumentality of crime. That is not a partisan talking point circulated by opposition researchers. That is the considered legal conclusion of a federal judge, and Corcoran's testimony supplies the narrative detail. Trump allegedly instructed him to certify a falsehood. That constitutes obstruction. It is a federal felony, and it is now documented in unsealed grand jury records accessible to every citizen. Trump's negligence actively endangered the national security of the United States. The photographs serve as the primary evidence for this proposition. The images of documents marked secret nophorn resting on the floor of a Mar-a-Lago bathroom are beyond the pale of defensible conduct. Consider the practical implications. Mar-a-Lago is a functioning commercial resort. Foreign nationals attend social functions and galas on the premises. Staff members who have undergone only minimal background checks possess routine access to these areas. If a foreign intelligence service sought to recruit a housekeeper or a member of the waitstaff to surreptitiously examine the contents of those boxes, the operational opportunity was abundantly present. The potential risk to human sources, to sensitive collection methods, and to the physical safety of intelligence officers stationed abroad is incalculable. And these photographs demonstrate conclusively that Trump either did not care about that risk or was too arrogant to contemplate it. In either scenario, it demonstrates a fundamental unfitness to serve as the steward of America's secrets. Yet, he presently receives the presidential daily brief each morning. The dissonance and the peril are overwhelming. The timing of this release functions as a political guillotine. This event is not occurring in isolation. It is unfolding while Trump confronts a renewed impeachment effort centered on his genocidal rhetoric toward Iran. It is unfolding while his administration suffers successive defeats in the federal courts regarding immigration policy. It is unfolding while his own flag officers question his judgment and stability. The cumulative weight of these overlapping scandals is forging a narrative that is impossible to escape. This man is unfit for office, he is enmeshed in criminality, and he is a danger to the Republic. The unsealing of these documents acts as an accelerant poured upon an already raging conflagration. Democrats are skillfully connecting these disparate threads. They are articulating a unified theory of the case. Observe the consistent pattern. He threatened to annihilate a civilization in Iran. That endangers American security. He abandoned nuclear secrets in a resort bathroom in Florida. That endangers American security. And when confronted with his transgressions, he obstructed justice. That is his essential character. This is the foundational argument for the upcoming midterm elections, and these unsealed documents constitute the Exhibit A that no impartial observer could reasonably dismiss. Republicans find themselves frozen in the glare of an oncoming political train. How does any member of Congress from a competitive district justify this record? How does a representative stand before a town hall audience and offer a coherent explanation for a photograph of a classified cover sheet resting on a ballroom carpet? They cannot. They are left with the hollow options of silence, deflection, or the exhausted mantra of the witch hunt. But the documents are real. They are tangible. They are public. And they represent a profound liability for anyone who chooses to chain their political destiny to Donald Trump. So where does this confluence of events leave the nation? A federal judge has unsealed a massive collection of incriminating evidence against the sitting president. Detailed obstruction schemes, sworn testimony from his own legal counsel, photographs depicting America's deepest secrets in a state of disgraceful disarray, all of it substantiating the allegation that Trump violated the law and treated national security with contemptuous negligence. And Trump is crashing out. He is on Truth Social, raging against the encroaching darkness, because he recognizes that this moment is qualitatively different. He understands that these documents have penetrated the barrier of public attention. He realizes that this evidentiary release provides additional fuel for the impeachment machinery and further proof that he cannot be entrusted with the instruments of state power. This story will not recede. These documents are now permanently embedded in the public record. They are searchable. They are downloadable. They constitute the unvarnished truth. And Trump's established defense strategy, deny, attack, and obfuscate, fails utterly when confronted with a photograph of the crime scene and the sworn testimony of his own confidants. The evidence articulates its own devastating narrative, and Trump's meltdown is the audible manifestation of a man confronting the reality that, for once, he cannot intimidate or deceive his way out of a documented paper trail. It is public, it is immutable, and it proves the central allegations. Trump is a criminal, he obstructs justice, he endangers national security, and now every American can witness it in the cold, unforgiving black and white of a federal court filing. As this evidence collides with the momentum of the impeachment push, the fallout from the Iran catastrophe, and the accumulating judicial sanctions, the pressure on this presidency is reaching a critical mass. These unsealed documents represent the latest and perhaps most damaging blow. With a majority of the American electorate already expressing support for impeachment, and with this evidence now fully exposed for every voter to evaluate, it is conceivable that we are witnessing the early stages of the endgame. Perhaps this is the moment when the institutional safeguards of the Republic finally reassert themselves. And Trump, crashing out in a frenzy of digital rage, senses it too. He knows the walls are finally, and perhaps irrevocably, closing in upon him.